aspects. So number one, employers are legally required to take every precaution reasonable in the circumstances for worker health and safety. What does that entail? That would include conducting a risk assessment. When should you be opening? Are you ready to reopen? How are you going to reopen? You're going to have to develop health and safety protocols and procedures for ensuring that you're minimizing the risk of COVID transmission in the workplace. Assess whether you may need personal protective equipment. May or may not be required. It may depend on the level of interaction the worker may have as part of their job duties with the general public. Okay, you're going to have to monitor employee compliance as well with health and safety protocols, and educate and train employees on how to work safely in the workplace, as well as informing employees about known hazards in the workplace. Okay, so those are the general obligations of an employer under worker health and safety legislation. So what are the employees' obligations? Well, health and safety in the workplace is a joint obligation on the part of employers, managers, and employees. So employees also have that joint duty to ensure that they're working safely. That means that they're required, and you can expect them to require with health and safety protocols. They have to wear health and safety equipment or protective equipment as required, and they're also required to report hazards. So that means that they should be reporting, and you can require that they report potential exposure in the workplace. So if they've been diagnosed and they've been reporting into the workplace, or they suspect that they may have COVID-19, even if they're not diagnosed with that, then you should be employing in your policies a reporting structure, and you can insist that employees report that information. In terms of what health and safety measures that should be implemented, you should be turning your mind to a variety of protocols and measures to be taken to ensure that their workers are safe in the physical workplace premises.
Jonquille, I'm sorry to interrupt. Are there slides that should be moving forward?
Yes. Are you seeing the slides? You should be
No,
seeing the slides.
we still have your cover slide up.
Okay. Let me see. There.
Thanks, Kelly, for pointing that out.
Thank you. Thank you. It was moving on one screen, not the other. So let me just move forward. Just bear with me. So we talked about employer duties, talked about the employee's obligations, and health and safety measures. So here we are. Apologize for that. Thanks for letting me know. So what types of safety protocols should you be incorporating in your return to work plans? Well, physical distancing has been identified as the most effective method of reducing the risk of transmission. It's well accepted among health authorities that is the main method of reducing the risk. So what does that entail? Taking a look at, we're going to have to look at your office layout and desk configuration, workstations, and so on. They recommend that workstations be at least 2 meters apart. You should have and turn your mind to directional traffic. So in a lot of the places, I'm sure you're seeing at retail stores and other commercial premises, directional stickers and signage in terms of workflow. You should also turn your mind to room capacity restrictions, for example, in common areas like photocopy rooms, mail rooms, lunch rooms, general reception areas. You may want to, in order to reduce crowding in the particular workplace, limit time in certain common areas, or require employees to book in advance, reserve space in advance. And at this point in time, the province has now limited social gatherings to 10 people maximum. They may extend that. So if there are any workplace social gatherings, keep in mind and definitely stay up to date in terms of what the rules and protocols are in connection with the size of gatherings. In terms of reducing, implementing the physical distancing protocols, this may require as well rotating shifts, right? You may not be able to, depending on your workplace configuration, you may not be able to accommodate everybody being in the workplace while respecting this 2-meter rule. So you may want to turn your mind to other ways to allow employees to get work done in the physical premises. That could include rotating shifts, working from home for employees who are not necessarily required to be in the office, conducting meetings by conference call, by Zoom. Outdoor meetings is also being recommended by health authorities, staggering lunches and break times, limiting work-related travel as well. You should also be keeping track of, if you're dealing with the general public, visitors on site. So you may want to turn your mind to scheduling visits by appointment only and in advance, so you can determine how many people are actually going to be on the premises. Screening visitors by either questionnaire or temperature screening if you're going to be interfacing a lot with the general public. Head counts potentially being done at reception. Sign in and sign out sheets is another option to consider in terms of controlling the number of people and knowing who's exactly on site at a given time. Personal protective equipment as appropriate may be required. So again, it depends on the level of interaction individuals are going to have with one another and the general public. So that could include requiring employees to wear face masks, not necessarily the entire day, but maybe in certain areas as appropriate, like for example, common areas. Alcohol-based hand sanitizer should be made available, especially in common areas, reception, your photocopy machine, basically common touch surfaces. That's where you should be including sanitizer or wipes, disposable gloves, sneeze guards. Those are also other types of protective equipment you should consider providing on site. Eye protection. Again, if it's an office environment, you may not necessarily need all of these types of protective equipment. It really depends on the nature of the operations and the interfacing with the general public. If there's very limited interactions with the general public, you may not need to take all of these steps in terms of personal protective equipment. Again, the health authorities are saying that it's not a substitute for physical distancing. So that should be the main sort of focus in terms of developing and crafting your protocols, is ensuring that you're controlling crowds, controlling the number of people, and to respect the physical distancing. Okay. Now, you may have some questions in terms of who should pay for the personal protective equipment. For non-union employees, you may want to check the employment contracts. There may be some provisions that relate to reimbursement for work-related expenses, and this would arguably fall within a work-related expense. That doesn't mean that you can't work out some agreement with the employees in terms of potentially cost sharing or the employees bearing that cost. But remember, the employer has a duty to provide the personal protective equipment, okay? So payment should not be an issue. You're going to have to find a way to ensure that it's there. To the extent that you want employees to shoulder some of that cost, you may want to consider a payroll deduction, right, for the PPP expenses. Okay, so the employer provides that as necessary and then is reimbursed either partially or in whole through a payroll deduction. Okay, employees can also bring in their own PPE as long as it's meeting safety requirements. So you should take a look at and have employees ensure that they're aware of the type of authorized hand sanitizers, face mask standards that are being, there are guidelines from the health authorities on that in terms of what's appropriate facial coverings, what's not, lists of sanitizers, disposable wipes, sanitation products that are authorized, not necessarily endorsed, but are authorized. So there's a list on Health Canada's website, okay? As part of your protocol, you should be reminding employees about hygiene etiquette. It may seem like basic common sense, but don't take it for granted. You should be reminding and including this in your health and safety protocol about hand washing, covering their mouth when sneezing, coughing, etc., using hand sanitizer, avoid shaking hands, having a clean desk policy to make it easier for it to be wiped down and cleaned by the cleaners. You should also include and consider policies for sanitizing the workplace. There is some evidence to suggest that COVID-19 can live on surfaces. They're not entirely clear at this point how long it can live. There's studies that suggest it could be hours and it could stretch out to a couple of days. So sanitation of common touch surface areas is and should be made as part of your mandatory safety protocol. So you should be verifying and checking, like if you're providing, if an external supplier is being engaged by your organization, you should be verifying with them what exactly they're doing. You may have to increase the number of times that they're coming in to clean and to expand the scope of their cleaning and ensure that they're actually sanitizing those common touch surface areas, okay? As well, if, you know, I imagine a number of the organizations that are in this audience are in a commercial building where there are other tenants and they may not necessarily control the entire footprint of the workplace. So you may, and you should be verifying, following up with property management services provider or the landlord to find out what they are doing, what steps they're doing to ensure safety protocol in those common areas like in elevators. There's probably going to be some capacity restrictions and you want to make sure that they're already turning their mind and implementing those types of protocol. Signage, foot control, as well as sanitation stations in various common areas. You should also, depending on the fitness of, you know, the age and of the building per se, you may want to verify as well that there's a good, that the airflow system ventilation is meets safety standards, is COVID compliant. And it, you know, you may also want to inquire and investigate whether they're also looking into touchless faucets, foot pedal garbage, cans, soap dispensers, etc. Okay, to reduce the transmission. So I recommend that you do follow up with your landlord or property management service provider. Employees should be informed and trained on safety protocols. If you're, depending on the size of the workplace, you may have a joint health and safety committee. So for workplaces in excess of 20 employees, you have a health and safety committee that would at least consist of 2 representatives. They should be involved in the process in terms of potentially developing, communicating the safety protocol. And you should designate a specific person within your organization to monitor public health directives, right? It's an evolving situation. We're in a constant state of flux. You know, they may be liberalizing and allowing workplaces to return, but then there could be a second wave and there could be a variety of restrictions that are being implemented and new measures being adopted and expected of employers. So you should designate at least one person to stay on top of the health directives as they arise.
Jonquille, there is a question that's very relevant for this section here. For employees who work with families in their homes, are there particular protocols?
So if they're a support worker, I mean, they would be, there would be, so in terms of protocols, certainly, like in the healthcare context, there are certain PPE and requirements to ensure that they're safe when dealing with individuals. And I am aware that there, to a certain degree, health authorities were limiting the number of clientele that they should be dealing with at a time. So I think it depends on the level of interaction. If they're just having a meeting with individuals in the workplace, or at least in their homes, you should consider alternative, because you know you have to consider limiting work-related travel and consider whether or not the visitation of various individuals in the community, whether that can be done through an alternative means, such as by phone, by Zoom, or other means. If they can't be, then ensure that they are following safety protocol to respect physical distancing, and they're wearing PPE if they're in somebody's home. Okay. So can employees, so I think, you know, common question is, can you require employees to stay at home? And yes, you can, for the health and safety of other employees. So if an individual has a positive COVID-19 diagnosis, if they're generally feeling unwell or have symptoms and suspect that it could be COVID related, they should be staying at home. Or if they're otherwise subject to an isolation or quarantine order, recently returned from international travel, had close contact with or living with somebody who's suspected of having COVID-19, or if they otherwise reasonably believe that they may have COVID-19, then they should be required to stay at home, and that should be built into your protocols. Can employees be required to report their diagnosis? Because of the concerns around the transmission of the virus and how highly contagious it is, yes, you can require employees to report if they are diagnosed with COVID-19 or if they have those symptoms. You should be instructing employees to contact their health provider or telehealth if they have those symptoms. You can require that they not attend work due to the concern about the spread. You should be considering about what to do if they can't be in the workplace. Can you accommodate a work from home arrangement? If you're, most office environments can accommodate a work from home situation. If they cannot carry out those functions and they're unable to work, then you can place them on a leave of absence, okay? So what do you do if there is a possible COVID-19 exposure in the workplace? How do you handle that? Well, the employer will have to take certain precautions. Exposure to COVID-19 in the workplace is considered a workplace hazard, so you're going to have to investigate it, determine and assess the level of risk to other employees. Is it possible that other employees may have been exposed? If so, then you have a duty to inform those employees if you have a reason to believe that they may have been exposed in order to prevent that reoccurrence and so that they can get tested. Okay, and you should also be ensuring that you immediately sanitize common touch surface areas that may have been exposed by the employee who has that COVID-19 diagnosis. You should also at the same time recognize that you have a duty to safeguard confidential health information for employees. So you should avoid naming the employee who was exposed to the extent possible. You can alternatively identify a work area, group, floor that they may have been working on as opposed to identifying the individual employee by name. You may be required to send employees home if it looks as though they may have been exposed. They recommend a period of 14 days, so 2 weeks. Ask them to self-isolate, monitor, and report any illnesses. There may be in some scenarios an obligation to shut down the entire office while it is being disinfected or desanitized or sanitized, I should say. So it depends on the situation, the level of exposure. If all of the safety protocols are being honored, people are keeping the social distancing, wearing PPE, maintaining the hygiene etiquette, then in most scenarios, you probably wouldn't have to shut down completely or shut down or require employees to stay at home. But if it looks as though there was a reasonable risk that people may be exposed, then that's when you have to consider sending a certain number of employees home or shutting down the office, okay? There is a duty to report to the Ministry of Labor if a worker is ill resulting from COVID-19 exposure, or they've filed a claim with the WSIB for COVID-related exposure. You must also notify, where applicable, your Joint Health and Safety Committee or a health and safety representative or the union, okay, if you're in a unionized work environment. You should also be reporting to the Toronto Public Health Authority or your applicable local health authority for direction. I refer to Toronto because I'm referring to those Toronto-based organizations, but I recognize that there may be a number of entities here that are outside the Toronto area, so report to your local health authority. They'll advise if preventative measures will be taken. So if you're unsure, you should be contacting them because they are taking the lead in terms of contact tracing and determining whether individuals need to quarantine or self-isolate.
Jonquille, before you move on, a number of questions for you that's relevant here. The first question is, can we ask all employees to get tested before they return to work? Can you ask employees to sign a waiver stating that they have no symptoms, and if they do get COVID, can be held liable, and can disciplinary action take place? Can you ask clients and staff before coming into the office if they have COVID or have they been exposed?
So in connection with the medical clearance, that's an excellent question because the health authorities are suggesting that employers refrain from asking for a medical clearance. It may be overkill to ask for every single employee for a medical clearance. The reason why they're discouraging organizations from asking for medical clearances is that they're in part dealing or trying to address with the public health crisis, so they don't want to inundate public health resources for all of these requests. Because if you think about it, all of these employers asking all of their employees to provide these medical clearances, it's just not reasonably practical. So there's no rule or prohibition that prevents you from doing that. They're not necessarily saying that it's a requirement as part of your due diligence obligations. So I think, so it's probably overkill, not necessary to ask for every single employee before they return to work to have a medical clearance certificate. I'd say it's not required for you to go to that extreme. If there are employees who are diagnosed with COVID, right, and they're off of work, they've had those COVID-related symptoms, you're not sure, they're suggesting that, and I have a slide deck that deals with that, but they're suggesting that they're safe to return after 14 days of the initial onset of symptoms, and as long as they don't continue to exhibit symptoms. That's what they're suggesting. They're suggesting that they don't need that medical clearance. But again, there's no rule preventing you from asking for that medical clearance certificate. So if you have some concerns about the employee not necessarily providing you with all of the information that you need, or you just want to have that extra precaution, then you can do it. It's not illegal to ask for it. The health authorities are certainly suggesting that it not be made a requirement. In terms of a waiver, at the end of the day, I don't think a waiver is necessarily going to immunize an employer from liability, right? Remember, there's a power imbalance between an employer and an employee, and the employees have a right to return to work, right? And it's expected and required that they return to work. If they don't return to work, they can be fired. So, the waiver would probably not be an enforceable waiver at the end of the day. If you're asking employees to return to work, and they're required to, right? And they need to, because they need to get, they need to earn a living. And it's not going to excuse you from your obligations to take necessary precautions. So it would be ill-advised to think that you have a bunch of employees sign a waiver and you're not necessarily taking all the necessary precautions, and you're thinking, oh, well, I got the waiver, so I have nothing to worry about. That's not the case at all. A waiver will not immunize you from your obligations under the Occupational Health and Safety Act, and it won't immunize you at the end of the day from liability. So the best way to protect yourself as an employer is to ensure that you're exercising due diligence in ensuring that the workplace is safe.
Yeah, there's a question here around, for screening purposes, can we ask clients and staff if they have COVID? And I think you addressed that right at the beginning when you talked about having a questionnaire can be one way of screening.
Yep, exactly. Yeah. Okay. You don't want anybody in your workplace who has COVID. And so you should be engaging in screening to ensure that people are safe and they're not going to expose other people to harm. Okay?
Yeah, and I think you've answered this, but it's coming up again. Are there protocols if an employee has to provide in-person service to a client who is suspected of having COVID? They have PPE. Will the employee be expected to stay home afterward?
I guess it really depends on, so I think it depends on the level of the service that they're providing. Like, they're healthcare workers. I mean, there's a considered essential worker, and there's an inherent level of risk associated with certain healthcare functions. If they are taking the necessary precautions like the physical distancing and wearing PPE, then the exposure is low. I think it's only if the employee is concerned that they do have a risk of potential exposure, something happened, they feel that they may be at risk, then you should be ensuring that they're not contaminating other people or contaminating the workplace. So it may be necessary, depends on the circumstances, to have them work from home or have them on a leave of absence if you think they're exposed, if there's a concern.
And one more question before I let you go is the second part to this same person's question. Are the protocols, especially around physical distancing, different for congregate living facilities versus a regular office?
As far as I know, the physical distancing protocol is across the board. They, you know, the science is a little bit in flux because I've heard various reports that, you know, the exposure can actually be there could be a broader parameter physically in terms of, you know, potential exposure to the virus, but they're saying across the board now, I'd say the health authorities anyway, that's who you should be taking a look at in terms of what they're recommending in terms of the physical distancing protocol, but across the board, they're saying 2 meters. So I don't, as far as I'm aware, it's not any different for the type of workplace that you're dealing with, whether it's construction, health, office environment. They are appearing to suggest that 2 meters is the standard that should be set across the board. Okay, but continue to follow up with your health authorities as more information comes out about the virus. You know, it's still very novel. It's still very new information, but that's, as far as I know, that's the universal rule right now.
Thank you. And before I let you continue, again, I think you said this at the beginning, around temperature checks. Are employers allowed to do temperature checks of employees and or clients?
Temperature checks, that can be a way of screening individuals to ensure that you know nobody's ill, nobody's has COVID-19 in the workplace. I think that's an acceptable screening procedure for visitors and workers coming on site.
Yeah, and can an employee refuse to return to work even though the employer has taken all necessary precautions?
So I'm going to deal with work refusals. So I'll deal with that. And if there's any questions, I'll, you know, feel free to ask, but I am going to be dealing with that.
Very good. Thank you.
Okay. So, and just going back to that, because you were asking about, we touched on this very briefly already, but the public health authorities, again, they're suggesting 14 days after symptoms start, and if they had COVID and they no longer present with COVID symptoms. And they're suggesting again that medical clearance tests are not required. Okay, so this is the topic that we were just discussing, work refusals. So what do you do if a worker refuses to work because of fear of COVID-19? There is a mandated process for dealing with work refusals under the Occupational Health and Safety Act. So employees actually have a legal right to refuse work that they believe to be unsafe. Now, there is a process that should be followed if an individual doesn't feel safe. So they have to report their health and safety concerns. So if they have those concerns, they must report it immediately to the employer. The employer then has a duty to investigate those health and safety issues. And you know, if the individual is in the workplace, then they have to remain in a safe place while the employer is investigating, or another part of the workplace, or from home, as the case may be, and they have to be available for the purposes of the investigation. And then there's a further step. Then, if it's, you know, if that health and safety issue has to be addressed, if you determine, well, there is a problem there, we're going to address it, then you have to take the necessary measures as appropriate internally to ensure that the workplace is safe. Now, if you're saying we think it's safe and the individual doesn't agree that the workplace is safe, then what happens next is that the employer and employee have to report the matter to the Ministry of Labor, right? Because and a Ministry of Labor inspector will visit the premises. So if the individual continues to believe the workplace is unsafe, notwithstanding the health and safety precautions the employer is taking, then the Ministry of Labor must be notified under the Occupational Health and Safety Act. And so that Ministry of Labor inspector will attend at the premises to investigate the health and safety concern. During that investigation, the employee can remain off work. They still should be paid while they're off work, or they can be assigned alternate work. Any staff that could be covering for the individual worker who's engaged in a work refusal has to be notified that the worker has refused work, and you have to notify the alternate worker of that worker's safety concerns. And then the Ministry of Labor inspector will conduct that assessment to determine, is there a workplace hazard that is likely to endanger the worker or another person? That's the test, okay? And the Ministry of Labor inspector, if they conclude that working conditions are unlikely to endanger anyone, then the worker is expected to return to work. So at the conclusion of that inspection, if the inspector says it's safe, then the employee has to return to work. They don't have a choice. They don't have a justification for refusing to work. If, on the other hand, that the inspector concludes that the working conditions are unsafe, then the Ministry of Labor inspector will generally order the employer to take whatever measures are necessary in the circumstances to address the health and safety issue. The reasonableness of a work refusal is likely to depend on a variety of factors, including the nature of the workplace, the employee's age and their health status, the proximity of workers or visitors, and the health measures being taken and implemented by the employer. So what if they just refuse to return to work at all? They're not in the workplace. You're saying, okay, we're, now that the province is giving us the green light, we're opening our doors, everybody's going to come back to work. What if they say, well, I don't want to return, I'm concerned, because there may be a number of employees who are concerned about taking public transit, the GO train, TTC, everybody cramming into those buses or trains. There may be also employees who generally fear that they're just going to catch COVID-19 out in public or in the workplace. But at the end of the day, if the workplace is safe, then the employer can require employees to return to work. And the best way to manage this, because you're probably going to get a number of employees who are subjectively going to be concerned about the potential risks of COVID, and to put employees' minds at ease, then employers should be developing a robust protocol in advance and educating employees on all of those health and safety precautions being taken so that they feel more comfortable returning to the workplace. Be aware that an employer cannot penalize an employee for exercising their rights under the Act to have either engaged in a work refusal. So if they're engaging in a work refusal in good faith, an employer is prohibited from imposing any type of a penalty or retaliating against an employee. The Ministry of Labor is anticipating, in the context of COVID, that there's going to be a significant number of workplace inspections and health and safety complaints. The province has already hired 58 new Ministry of Labor inspectors throughout this pandemic. So far, according to certain stats, there's been over 5,700 related COVID complaints, both in Ontario and Quebec. Labor inspectors have already completed about 8,600 field inspections, some are in person, some remotely. And it's interesting to note, though, among all of the complaints and the concerns, only a very, very small fraction of those health and safety complaints have been upheld. So be aware that generally, you're not necessarily going to get the Ministry of Labor just, randomly knocking at your door. You should be ready with any type of inspection. Typically, Ministry of Labor inspections are complaint driven. So that means an individual's either provided an anonymous tip to the Ministry of Labor that they have concerns about an employer's compliance, or an individual has engaged in a work refusal, triggering the obligation to notify the Ministry of Labor if the parties haven't been able to resolve it internally. There can be Ministry of Labor inspection blitzes. Typically, they publish it on their website in advance, but the certain sectors that they're targeting. So there could be random inspections, but typically that's based on industry, and usually it's higher risk industries. So I would expect retail, healthcare, other areas where there's higher risk, I would say, of exposure, that we can expect more of those blitzes. There are penalties under the Occupational Health and Safety Act if an employer is found to be non-compliant with the legislation. So compliance orders can be issued by inspectors. Again, so there have been, and I've heard anecdotally about inspectors, and it's been reported in the news, just shutting down, ordering employers to shut down. I know one case where an employer wasn't aware of this, but an employee was just returned from Florida, was talking in the lunchroom with employees how he just returned from Florida, and then somebody in his family he was living with had COVID, yet he was still reporting into work. And so somebody had called the Ministry of Labor, and the inspector closed the entire operation down. So it can happen. If an employer is not exercising due diligence, if it's found to be non-compliant with the legislation, there are penalties. So there can be fines, there can be provincial charges. These are maximum penalties that are listed here. There's 100,000 for an individual, could be up to 1.5 million for a corporation. There could be imprisonment. Typically, these are in very extreme, rare scenarios. In cases of unlawful reprisal, so if an individual is unlawfully terminated because they're exercising their rights under the Act, the employer could be ordered to reinstate the individual with back pay, where it's seen to be an unlawful reprisal. So I just want to go over leaves of absence, because there are certain scenarios in which an employer is actually statutorily obligated to provide leaves of absence in certain circumstances, and this has been outlined in recent amendments to the Employment Standards Act. So the employers have to grant a job protected leave in the following situations, and it can be a leave without pay. There's no obligation to pay an individual if they're not working, unless you have a contract or collective agreement that provides otherwise. But leaves of absence have to be granted if an individual is off work because they're under investigation, they're undergoing testing for COVID, they're engaged in self-isolation or quarantine under public health directions. They have to be away from work because of school closures or daycare closures. They need to be away from work to care for certain designated family members, not just any family member. There's a certain list of family members where they can be away from work in order to care for them and provide support. If they're unable to work as well due to COVID-related travel restrictions, or they're otherwise relieved of duties because of a concern that they could spread COVID in the workplace. For a leave of absence, you're actually in this scenario prohibited for any of those types of leaves of absence that I mentioned. You're prohibited from asking for a medical note in order to take the leave. So they're entitled to the leave. You can't ask for a medical note. So if somebody says they're under orders to self-quarantine, or they have COVID or COVID-like symptoms, you should not be asking for a medical note. But you can ask for reasonable evidence in the circumstances beyond a medical note. So for example, if there's a daycare or school closure, you can ask for a note from their daycare provider or school, as the case may be, a note from a family member, or if they are unable to travel, evidence of canceled flights. There's other types of information that you can ask for to corroborate the need for a leave of absence, but you should not be asking for a medical note. So as I mentioned, there's no requirement to pay wages to an employee if they're not working because of COVID. You should check your own policies and benefits to verify the availability of paid time off benefits. So for example, sick leave, there could be paid personal days, floater days. If there's short-term disability leave benefits for an individual who's ill, so this is for personal illness, they may be eligible for the short-term disability leave benefits. So employees should be made aware of those paid time off benefits that could be available to them. If there are no paid time off benefits, then if they're on a leave of absence, you're not paying them. An ROE would have to be issued, and they can apply for EI benefits, or they can apply for the CERB. You can also get creative if you're trying to assist an employee to alleviate the financial burdens of being on a leave of absence. So you can allow the employee to use vacation or borrow against future vacation or paid time off benefits. So you can and should probably turn your mind to whether those benefits can be afforded to individuals who are unable to work. Now, vulnerable workers. Now this is an area that can get tricky, and this will always have to be dealt with on a case-by-case basis, and your policies and protocols should have enough flexibility to ensure that you're being reasonably accommodating of individuals who may be at higher risk. So not everybody's got the same level of risk when it comes to COVID. We know that with COVID, vulnerable workers, that is individuals who are over 65, who have compromised immune system or underlying health condition. If an individual self-identifies as being vulnerable or they're living or caring for an individual is vulnerable, you may have a duty under human rights legislation to reasonably accommodate them, and provide alternative forms of allowing them to meaningfully participate in the workplace. And it could be that you may have to allow these individuals to work from home for an extended period of time, while others may be, required to return to the workplace. So under human rights legislation, just very generally, an employer has a duty to accommodate individuals who have a disability to the point of undue hardship. And you have a legal duty to reasonably accommodate individuals with child obligations. So these are necessary obligations. So it's not, you don't have a duty to accommodate individuals who, need to take their kid to soccer practice. But if there is a situation like when we're dealing with COVID, where there's school closures, daycare closures, they don't have another family member who can help out or is available, or a cost-effective alternative of childcare, safe and cost-effective, then you may have a duty to accommodate them, to allow them to continue working from home for a reasonable period of time, depending on what their needs are. Be aware that a disability under the Human Rights Code is probably going to be interpreted broadly to include any underlying illness or injury that could put them at heightened risk, preventing them from participating in the workplace. So, a uniform policy that's not necessarily targeting vulnerable workers or individuals with family care responsibilities, if your policies are rigid and don't allow enough flexibility to take into those circumstances of the individual worker, and has an adverse impact on people who are, based on their age or an underlying health condition, then they may be viewed, your policies could be viewed as discriminatory in nature. You don't want to be in a situation where you're potentially violating human rights legislation. So ensure that your policies are flexible enough to deal with circumstances on a case-by-case basis if there is a compelling need to work from home. Okay, and be aware that when it comes to the duty to accommodate, say, vulnerable workers or older workers or individuals with family care responsibilities, it doesn't necessarily mean that you have to grant the individual's preferred or ideal accommodation. The duty is to provide a reasonable accommodation in the circumstances, take into account their restrictions. Unless the accommodation would pose undue hardship. Like, for example, if the accommodation would pose excessive costs, other health and safety issues or legal compliance issues, then you could say, well, we can't accommodate. But in the vast majority of cases, if we're talking about office environments, the undue hardship threshold is going to be very high. Types of accommodations, short of, requiring employees to be off of work, could involve modified work schedules, modified deadlines, or job duties, working from home arrangements, flexible scheduling. And if those measures can't be implemented, then providing them with a leave of absence without pay. Whatever the accommodation is, it should have the least detrimental financial impact on the individual. So instead of unilaterally placing them on a leave of absence, assess, can they work from home, or can we modify their schedule so they can come in at different times? And that's an analysis that should be undertaken where you have an individual who's got those compelling needs. And in that scenario, if somebody is asking for an accommodation because they self-identify as being vulnerable, then you can require a medical note from a doctor or a health professional to support their need for a special accommodation.
Jonquille, there's a question around this. Is there a way to verify an employee is living with someone who is vulnerable? And how much information can you request?
So
just one question.
Yeah, in that scenario, I would probably recommend, if you want further information to satisfy yourself that there's actually a need to accommodate them, you can require a medical note from that vulnerable person's health professional indicating that this person is vulnerable. You don't necessarily, and you're probably not necessarily going to be entitled to know the individual's health condition, because that's their private health information, right? Provided that they consent to this disclosure. They can get a medical note from the family member's doctor to say that this worker is a caregiver or lives with, an individual who has an underlying health condition who's identified as vulnerable. So that could be a form of evidence that can be provided and you can ask for in the circumstances. So in some ways, it's going to be very hard to police who's living with, whether they're actually living with somebody or caring for somebody. So you're a little bit at the mercy of the employee, and there will be a trust factor there. It's really, really going to be hard to enforce all of that, in terms of what's going on in people's homes and what their living arrangements are. But that is, a reasonable request to ask for that documentation.
Yeah. Is an employee who is pregnant considered vulnerable?
I'm not a health professional, so I'm reluctant to answer that question in terms of identifying whether that person is vulnerable. There is, I think, mainstream media has reported in some cases that they should take extra precautions. But based on Health Canada, if you just go to the Health Canada website, at the end of the day, you should be going to public health authorities, their websites. They put out a lot of information and guidelines about what the risk factors are. They don't identify them, at least in my recent research, they haven't identified pregnant employees as being vulnerable. That being said, if they self-identify as being vulnerable, then you can ask that doctor's note, right? If their doctor is saying they can't work because they have, unique complications, because every pregnancy may be different, right? Somebody may have underlying complications associated with their pregnancy, and that might put them at risk. And so at the end of the day, you should refer to those public health guidelines in conjunction with information being provided by that individual's doctor. That's the go-to source, is really referring to their doctor's health directions.
What about employees who are refusing to work because they are afraid of taking public transportation? That
probably won't be an adequate, again, but setting aside vulnerable workers, being afraid of public transportation will not be a reasonable excuse to avoid returning to work.
But if you had an underlying health condition or those kinds of things, then
I think that's a reasonable assessment that should be in terms of your accommodation analysis, because it's not just the workplace, it's reasonably getting to the workplace as well. And that's a viable risk. It's a viable concern, riding the rocket almost every day to and from work. How crowded the public transit can be. I know that they're taking measures. So I think in large measure, there will be some guidance probably that will be provided to a number of organizations grappling with this issue. All of the financial district in Toronto, where everybody is, it's a very condensed work environment. Everybody is dealing with that same issue and that same problem. We're all navigating this together. What I would say is I reasonably expect that public transit authorities are going to be providing further guidance. They have an obligation to ensure the safety of their services as well. So to the extent that you're providing a safe work environment, the government has given the green light for people to return. It won't be an adequate excuse for most workers to say, I'm just afraid of taking public transit. You can require, my view is you can require that they return to work, setting aside your vulnerable workers.
Yeah, 2 or 3 more questions. What happens if everything is in place and an employee still does not want to return to work, but they cannot perform the job from home?
So if it's a job that cannot be performed from home, and the workplace is safe, you can require that they attend work. If they refuse to attend work, then you can say, well, you're going to be fired, right? You're entitled to say, you are required to return to work. We are taking all of those necessary health and safety precautions. Be cognizant of the process that should be followed in terms of potentially having to contact the Ministry of Labor if it's a work refusal. So if it's deemed safe, then they don't have an excuse. You can expect that they return to work, and if they don't, you could fire them for insubordination, being absent without authorization, or you could treat it as an abandonment, potentially an abandonment of their job. Now, this will always have to be assessed on a case-by-case basis. Every situation is going to be different, but an employer would be most likely within their rights to discipline or terminate the employment of the individual who's refusing to return to work without adequate excuse.
And another question under this, how do you handle the issue with daycare? Lack of daycare impacts workers. How flexible does an employer have to be?
Well, if an individual, so it's gonna, so this triggers the conversation around accommodation, right?
Yeah.
So just be aware, under the Employment Standards Amendment Act, they've deemed it an emergency leave. That means it's a job protected leave if they're unable to work because of daycare reasons. So if you're in a situation where employees indicate that they don't have any other alternatives, you may be, unfortunately, in a situation where you may have to accommodate that leave of absence or work from home arrangement. It will really, every individual situation is going to be different. So some workers may have a partner who is going to be shouldering in that obligation, or other family members, or they may have a babysitter, in which case, it's not an adequate excuse that they just want to stay at home and potentially reconfigure their schedule accordingly, or be there for their kids. It's only when it's a need and they don't have a reasonable practical alternative in the circumstances that you have that duty to accommodate them. Okay, so if daycare is not available and they have no other alternatives, then you may have to accommodate a work from home arrangement for a period of time until those services are available.
In terms of caring for someone who is vulnerable, like an elderly parent, do they have to be in the same household for accommodations to be put in place, or can they be in separate households?
Well, so this is where you're looking for direction from the health care practitioner, who may be able to weigh in on whether somebody needs to be away from the workplace because they are caring for somebody who's vulnerable. So I don't think the test is that rigid that they have to be in the same house. That, there could be situations where you have obligations to care for an individual who may be outside the household, but you're for instance, they're dependent on you. They could be a family member whose high needs is vulnerable, and they're dependent on you for or the employee for various activities of daily living. And if somebody, for instance, my brother who's autistic, he has a caregiver, he lives in his own place, but I'm often shouldering that responsibility in terms of caring for him. And so you don't necessarily need to be in the same house to potentially have to accommodate them. If they're in physical proximity because they're caring for them and they are that caregiver, then I think that's enough to trigger potentially a duty to accommodate.
Okay, and this last question before I let you go on belonged, I think, in an earlier section. If and when a staff who is doing employment support services place a client in a workplace for training and or employment, do you know if there is an extended responsibility and or liability by the agency around health and safety in that workplace?
So I'm actually gonna address that in subsequent slides in terms of the employer's liability if somebody catches COVID in the workplace or arising from work duties. So just hold that thought. If there are additional questions that flow, then
very good. Thank you.
So just want to very quickly turn to temporary layoffs because I imagine, as most employers are going to have to deal with how to deal with the decline in revenues associated with shutdowns, triggering temporary layoffs. Some of your staff may already be on temporary layoffs. So be aware that the province has extended the temporary layoff rules. Typically and historically, it's been 13 weeks in a 20-week period or 35 weeks if you're continuing benefits. Through a 52-week period of time, you can temporarily lay them off without triggering any kind of severance obligation. Now they've extended temporary layoffs. They've actually deemed temporary layoffs or working under reduced hours due to COVID-19 as an emergency leave. So that means it's a job protected leave. So what that means is that if you're not ready to return them after the 13 weeks or the 35 weeks, for the time being, you can continue that temporary layoff without having to worry about paying them out, treating it as a permanent layoff or paying out a severance package. In the past, a reduction in hours or temporary layoff has been treated as a constructive dismissal, meaning that the employer has made fundamental changes unilaterally to the employment relationship, triggering a severance obligation. Here, the province has removed that, so they're saying that, you know, in these circumstances, the temporary layoff, reduction of hours is not a constructive dismissal. So this is some comfort to employers to, you know, to the extent that employees are asserting any type of severance claim or constructive dismissal damages. This is a form of protection. It's actually a good step for employers not having to worry about those drastic changes. The temporary rules will not be in place forever. They are set to expire 6 weeks after the declared emergency ends. They don't apply to employees in a trade union. So upon an expiry of a temporary layoff, so eventually when you say we're ready, you're expected to return to work. Employees can be returned to work, provided that you're taking the necessary precautions to ensure a safe work environment. So just be aware that when you're returning to work, like when you're asking employees to come back to work, but you intend to make some significant changes to either, you know, to people's jobs, to their pay, to their hours, be aware that once they're back in the workplace and outside these temporary temporary rules that are being put in place for the deemed emergency leave, once they're back and things are sort of resuming back to normal, you still have to be concerned about potential exposure around making significant changes to terms and conditions of employment. It can trigger constructive dismissal, which is constructive dismissal is a situation which an employer is fundamentally making changes to terms and conditions of employment without the individual's consent. They can resign in those types of scenario and demand a severance package as though the employer terminated the relationship. Not all changes will amount to constructive dismissal. It's only changes that are considered fundamental in nature. So material diminution in authority, a demotion, moving somebody from full-time to part-time on a permanent basis, that could trigger a constructive dismissal. Significant pay cuts. I think, you know, the higher the pay cut, the more likely you have a constructive dismissal exposure. There's some case law that says, well, once you get in the range of 15% or more, then you have a heightened risk of a potential claim for constructive dismissal. If you're going to be permanently laying employees off, then this will automatically trigger severance obligation. And so you have to factor that in terms of your potential expenses and liabilities if you're expecting some downsizing. The minimum statutory notice requirements of the Ontario Employment Standards Act, it varies between 0 to 8 weeks, depending on their length of service. You can either give statutory working notice or termination pay in lieu of working notice. In addition, you may have an obligation to provide statutory severance pay. So for any employee who's got 5 or more years of service, and if you have a payroll in excess of 2.5 million, the severance pay formula is 1 week per year of service and prorated for part years. And this is in addition to the statutory notice or termination pay in lieu. Okay, be aware that this is just the minimum severance obligation. There is a common law obligation for non-union employers to provide, so for any individual who's a non-union employee, the employer must provide reasonable advance notice of termination or payment in lieu, which is the severance package at common law. So for illustrative purposes, I refer to the common law as the ceiling or the gold standard when we talk about severance packages. So common law severance is not based on a predetermined formula. It's based on the courts and what the courts would consider fair and reasonable. And typically they're looking at a variety of factors and assessing what is a reasonable severance package. They'll take a look at the individual's age, their character of employment, the length of service, their compensation level, and availability of securing a comparable job in the marketplace. Common law severance, be aware, is significantly more generous than employment standards. In some cases, there are decisions out there, depending on the individual circumstances, where courts have ordered employers to pay up to a year or 2 years worth of severance. So it's not a trivial obligation. It can be significant, and so you have to factor that in assessing what your potential severance payouts might look like to the extent that you're permanently laying people off. If you're laying people off not due to economic circumstances, that will not be a justification to excuse you from your severance obligation or reduce your severance obligation. So your financial circumstances are completely irrelevant to what your severance obligations are. So in determining whether or not you're obligated to pay out the common law severance, you should take a look at the individual's employment contract to determine, is there a termination clause? Does it address terminations without cause, for example, a layoff? If so, what does the termination clause provide? If there is no clear termination formula, then by default, at-law individuals are going to be entitled to common law severance. Okay, and you should get advice from an employment lawyer in terms of what that severance obligation might look like. So turning to the question, the earlier question about can you be sued, what is your liability if somebody is catching COVID either from the workplace or arising as part of their work duties? Can they sue you? Is an employer liable? So first, it will depend on whether or not the employer is part of the workers' compensation regime, okay? If the employer subscribes to workplace safety and insurance board coverage, so they're either a Schedule 1 or Schedule 2 employer under the scheme. Schedule 1 is they're mandatory, and then there's other employers that can actually voluntarily opt into WSIB coverage. This is a no-fault system, and if you have WSIB coverage, employees are precluded from suing the employer for catching COVID in the workplace, notwithstanding that it may arise from their duties, regardless of it, and it's regardless of whether an employer is actually negligent or not. They don't have recourse to the courts. They cannot sue the employer. They have to go through workers' compensation, and they have to make a claim for workers' compensation benefits. Okay, they can, and if it's determined that they've suffered some illness as a result of COVID, they could be entitled to, and catching it by virtue of the workplace. The individual can be entitled to various benefits, including loss of earnings benefits. They can be entitled to compensation for certain medical expenses, drug expenses associated with treating COVID-19. And it's only they're only eligible for benefits if they actually suffer from COVID symptoms. Benefits, the WSIB policy is that the benefits are not available for COVID-19 positive workers who are symptom-free. The question is, how are you going to know, though, if they caught COVID from the workplace? How is there really any way of knowing that? They could have caught it on the subway or in the grocery store. How do we know that it's actually related to the workplace? The WSIB has created a policy on how to adjudicate and deal with COVID-19 claims. The Workplace Safety Insurance Board policy is that employees are entitled to benefits if the nature of the employee's work created a risk of contracting COVID-19 to which the public at large is not normally exposed, and the worker, their worker's COVID-19 condition has been confirmed. So there has to be some evidence to establish that the worker actually has COVID-19. So in terms of the first part of that analysis, though, how do we determine whether there was that risk over and above, the risks that may be exposed to being in the public at large? So a couple of factors that they're going to consider, was there a contact source? So was there any evidence to suggest that there was somebody else within the workplace or client visitor who may have had COVID-19 and thus exposed the individual worker? Does the nature and location of employment activities place the individual at higher risk of being exposed to the virus? Was there an opportunity for transmission in the workplace? And they're going to look at sort of the timing around it. What was the incubation period? What's the date of exposure, the date of illness? Does that coincide with when they were in the workplace? So they're going to look at all of those factors to assess whether or not there was that risk, heightened risk there associated by virtue of the fact that the employee may have caught the COVID-19 in the workplace. They're going to look at whether there was that heightened risk and exposure. It won't be assumed. Now, Interestingly, there was a private member's bill that was actually passed, not passed, sorry, it's gone through first reading. It is only a private member's bill, so it may not be, affected into law. It may not be passed ultimately, because very few private members' bills actually get passed into law. But it's an interesting bill that you should keep abreast of if you're a part of the Workers' Safety Insurance Board scheme. If passed, what the bill is proposing is that it creates a presumption that if the individual works for an essential business and they test positive for COVID-19, that they caught it in the workplace, unless the contrary can be established. Okay, so this bill, if passed, would create a presumption that if somebody catches COVID-19, they're in an essential workplace, then it's going to be presumed that they caught it in the workplace. Okay, so for many of you, this may not even apply because it may not be considered an essential business. So this is only intended to capture workers who are working as part of an essential business. What this is intended to do is really ultimately make it a lot easier for individuals to get WSIB benefits if they have a COVID-19 positive diagnosis. It is intended to apply retroactively to June 25th. So for any claims that have been denied since January 25th, those denials will be vacated and individuals can reapply for WSIB benefits if this legislation is passed. Okay, well, what about those employers who are not covered by WSIB? Can you be sued if somebody catches COVID-19 in the workplace? Well, employers have a common law duty to exercise due diligence for the safety of their workers. And so employees can bring a claim for damages against an employer if the employer fails to exercise due diligence. You have a duty of care to your workers at law. And so if an employer is not taking reasonable precautions, if their negligence has resulted in exposure to the virus, resulting in severe illness or injury or death, then an employee can sue and claim against the employer damages for COVID transmission in the workplace. Now, again, they would have to ultimately establish that they caught that virus by virtue of the employer's negligence. There still has to be that nexus, and it may be ultimately very difficult to prove. But at this time, there is that common law duty. Employers can be exposed to potential liability if they're not exercising due diligence. What does that mean? If they're not exercising and taking reasonable precautions necessary for the protection of workers. So that's why employers should be abundantly cautious and ensure that you have that robust system in place to ensure that the workplace is going to be safe for individuals to return. And be aware that it doesn't necessarily, negligence can flow for, or liability can flow to an employer if COVID-19 is caught arising from work duties. So it doesn't necessarily have to be from the workplace itself. I think to the earlier question about if they're catching it being in the community as part of their job duties, so just be aware that it may still be difficult to actually prove that it was the employer's negligence that ultimately resulted in COVID-19 transmission. But COVID-19, but that liability can flow as a result of an employer's failure to take those necessary precautions for the worker. It doesn't necessarily have to strictly result in exposure from the workplace. So for instance, you're requiring employees to put themselves in situations in which they're placed in unnecessary or undue risk. That could be a scenario, and it could be outside the workplace. So for work-related travel, interactions with clients, you're putting employees at undue risk, then the liability can potentially flow. Okay.
Jonquille, just to ask that other question, and it's really around third-party liability. So if part of my job is placing people in employment with a different employer, can I be held liable as the service provider because I've placed my client in a job?
Right. So in order to establish, like, it has to be a duty of care. So there has to be a relationship and a duty of care to the client per se. It could depend on the nature of the services. arguably, I would say if it's a type of social service, healthcare service, I would say that there's arguably that duty of care that would flow to the client or the third party in that scenario. So first there has to be a duty of care, and next they have to establish that the employer failed to meet the necessary standard of care. So if there could potentially be liability to third parties if you're not ensuring that employees are properly trained or properly taking precautions for the safety of third parties as well, with visitors on your site, for instance. You're not taking the
Okay, so let me play this out because this is important for many of our employment agencies. So are you saying that as an employment agency, before I can place a client in a job, I must ensure that that workplace where I am referring my client for training or work has taken into account health and safety considerations? So if I am sending a client to work with you, am I responsible if the client gets COVID from working with you?
So the client. So when you refer to client, can you just clarify what types of clientele you're talking about?
These are adults. These are immigrants who have just come to Canada looking for work. I provide employment supports. They come to me. I find them a job. I place them in that job. Am I reliable if they get COVID from that job?
So I think that's an interesting question because they're not an employee of yours.
That's correct.
It's more of like a referral. Is it fair to say it's more like a referral, like what you're referring them to?
Yes.
So, I mean, you're providing them with a service to help them ultimately integrate into the job market.
That's right.
I doubt there is a duty of care to the individual client where you're just providing a referral source, right? The duty of care will definitely flow from the employer to if they're hired on as a volunteer, if they're hired on as an employee. I don't think a duty of care would flow if you're just providing a referral service.
Okay.
That's why I was asking about client, like if it was a situation which, we're talking about like support workers who come into homes to provide care support for individuals. It's a very different scenario where they're reliant and dependent upon those services for activities of daily living. That's a very different scenario than a client who's just, you're providing them with a general service that puts them in connection with other entities. I would say that nevertheless, I would exercise precautions to find out if those employers are, providing or have a policy in place for the protection of workers. You can make those inquiries. I don't think that there's a duty of care there.
Yeah. And so the next, if there's a follow-up question as you were responding, then should organizations be clear about providing their clients with information before they refer them then around health and safety, those kinds of things? To them, responsibility too.
I mean, it may be good. It may be a good precautionary measure to provide them with general information about the risks of COVID-19, to pose those questions to their employers, to remind them that they have those rights and that those are questions that they should be following up with their employer with. Okay.
Yeah.
Okay.
Yeah, and I think you've answered this in actually your response. But what about the duty of care for staff of the agency who must go into this second organization to facilitate the referral?
Right. So this is part of their job duties, right?
That's right.
And so the workplace obligations could extend to outside the physical premises. And therefore, you have that duty of care to your workers. You should be exercising precautions to ensure that they're safe. If you're uncertain, then you may have to not have them in those environments or places until you're satisfied that reasonable precautions are being made, right? Because anytime you're requiring individuals to visit certain sites, that becomes part of your obligation to ensure that they're safe. So you should be following up with those entities to find out, that they're taking reasonable measures for the safety of of individuals on site, including visitors.
Good. It says, is the duty of care of an employer the same for both?
And actually, just before we go on that point, like, you may also consider whether they actually physically have to be in those workplaces. Like, they may be able to carry out their job functions remotely, and that's the safer approach, quite frankly. So to the extent that they're meeting with various workplaces because they're interested in hiring certain immigrant groups, and and there's that referral relationship being established, and you're getting to know that organization. Do you need to actually physically be there or does the worker have to be there to meet with them? Meetings can be conducted by Zoom or conference call. They may be able to interface with that organization without physically having to attend. One of the recommendations from the health authorities is that work-related travel be limited. So at least for right now. So that should be the go-to presumption, is that individuals should probably refrain from visiting those premises unless it's required.
Yeah, so three follow-up questions to this section. Can employees refuse work if the employer asks them to be redeployed to work in an essential service in the organization that is other work than the employee was initially hired to do?
So can they be redeployed to do something else? Can you require them to work somewhere else within the organization? So this is where you could run into constructive dismissal issues, right? If the workplace is safe, you can make reasonable changes to their job functions, job duties. That being said, if they're considered fundamental changes to terms and conditions of employment for non-unionized employees, if they don't agree with it, they may potentially claim that they've been constructively dismissed because they don't agree with these fundamental changes taking place. It could trigger a severance obligation. That's going to have to be assessed on a case-by-case basis. The more fundamental and drastic the changes, the more your risk is heightened about potential constructive dismissal claims. So be aware that employers can make some changes to the work environment. No workplace is static, but if you're making permanent changes to job descriptions, people don't agree with it, it could potentially trigger that severance obligation.
Thank you. Do you have the same duty of care to volunteers as you do to employees?
Yes. Yeah.
Okay. That was quick. Good. I believe those are all the questions in this area. And folks were just reminding others that in terms of placement of clients with employers, you need to you need to confirm with the third party that they have insurance, including WSIB, before a placement is made.
Sorry, is that a question to me?
No, it was a comment. I was just letting people know that some of their colleagues are also answering some of their questions.
Okay.
Go ahead, please.
Okay. And I think I'm close to wrapping up. There we are.
Oh, good.
I think that went longer than the intended half an hour, but I'm opening, the floor is open for any additional questions. I know, at the end of the day, these are rapidly evolving times. The law is changing. The law has been changing quite rapidly as well. So stay abreast. If you have, if there are specific circumstances, that you need some advice on, consult with an employment lawyer. If there's any specific scenarios in your workplace where you're not sure how to handle it, you want some specific advice, feel free to contact me. I can make, what I'll do is, Debbie, I'll forward to you a copy of these slides. The slide deck, so you can make it available for participants.
Very good.
So all informational only, is not intended to be legal advice in connection with your own workplace situation. So do follow up with any specific advice that you need. Do not hesitate to contact me.
Yes, there's a daycare question. What if daycare is open, but the employee is concerned about sending their child or children to daycare? Can they refuse to return to work?
So I think everybody hates the answer. It depends. So is there a viable reason why they're scared? It's just like the scenario in which people are generally afraid of coming into the workplace or using public transit. I don't think that will be an adequate excuse. If daycare reasonable, and precautions are being taken, like if they come back and they say there's, there's a concern around the daycare being compliant in my neighborhood. That could be an issue where you may have to assess that. If their child has a pre-existing or underlying health condition, that could be a scenario in which they may be justified in not taking their kids to daycare at this present time. But if it's a general fear, I don't think that there would be an obligation to accommodate them. This is a general risk that the community at large will have. And it's only, I think, very narrow sets of circumstances where we're dealing with vulnerable individuals or people who live with vulnerable individuals that you may have to make those added precautions or accommodations for them. But I don't think that would be an adequate excuse if daycare is available.
We have one question. Someone is asking regarding the age of vulnerability. Various legal presentations have said either it's 60 plus or 65 and up. Can they get some clarification on that?
So again, I'm not a health professional, so I'm not going to provide any kind of advice on the medical front. But what I have read, and I think what the prevailing view is based on all the materials that I've read so far, and if you take a look at Government Ontario, Government of Canada, your local public health authority, there's information that they have published in connection with people who are identified as being vulnerable. The material that I've read is 65. Okay, and will that move? Maybe maybe it's a moving target. We've been getting a lot of conflicting information, even from health officials, because this is a new virus, because they were initially unsure about how it spreads, who's heavily impacted by it. But I think, based on sort of as the situation's been evolving right now, I've seen materials that say 65. Debbie, you're on mute. I can't.
Thank you. Okay, folks, this is your time to ask questions of Jonquille. Okay, thank you so much. That was so very thorough. I think folks were asking questions as you were going along. I'm just checking. Oh, this is wonderful. You can see everyone. We can see names.
Oh.
Use your chat if you would like to speak. Raise your hand. Marnie? No? You're just waving hello? Did I see someone? Michelle, did you want to ask a question? Michelle Schreier?
I think it's been answered, but I think. Thank you. Thank you so much for this.
No problem.
Thank you, Michelle. Folks are saying that you were very clear. Jennifer, I'm seeing you come on. Did you have a question?
I do have one question, and I came into the webinar a little bit late, so I apologize if this has already been covered. But in terms of my understanding, I've heard from some people, like if this goes on 6 months or less, we only have certain duties to accommodate in terms of furniture setups and people's home work like environments. But if we had some staff that had to extend working remotely over 6 months, what duties do employers have to then start shipping furniture, like in terms of stand-up workstations and all those kind of things that people might have been accommodated with in the workplace?
So are you asking about providing employees with office furniture from the workplace so that they can use it in their home office environment?
That's right.
Okay. So if employees have certain medical accommodations for ergonomic equipment and it can be easily made available to them, I think that most likely an employer will be viewed as having an obligation to provide that equipment to them to ensure that they're able to work without causing risk of re-injury to themselves or aggravating an existing health condition or injuries. So I would recommend that employers in that situation provide the equipment available. There's the shipping costs, there's some logistics that may have to be sorted out, and you can expect the individual to cooperate in that process. But I would recommend that employers in that scenario provide the equipment to them.
Other questions?
Mary
Can you use your
has her
chat?
hand up. Mary.
Go ahead. Is that Don Michael who has a question? No? Selena, who had a question?
Sorry, it was Mary Langibar?
Yes. Hi. I just had a question in regards to, I'm not sure whether or not this is something that can be covered. That the question is that what if an employee has other obligations, for example, like outside of the work, that they have a different work, that they're at a higher risk of being exposed to COVID-19. So what is the employer's obligation for other employees, and what liability, I guess, that it proposes for the employer?
Well, the employer should, like if there's reasonable grounds to believe that the individual has been exposed to COVID-19, then you can require that they remain, in a work from home environment, or if work can't be completed at home, that they take a leave of absence. It could be considered that job protected leave of absence. But merely working elsewhere, like for example, if they have a grocery, like they work at a grocery store, it'd be different if they're in a healthcare environment. But if I don't think that would per se be enough to say that we think that there's a live risk here that you pose. Subject to what health authorities say, I don't think that would be enough. If they present with symptoms, they've been diagnosed, that would be a scenario where you should consider in those specific set of circumstances requiring that they work from home. Remember, if you're engaging in, you're never going to be able to eliminate the threat of COVID-19 in the workplace. The physical distancing measures, if they're being adopted, presumably, even if somebody does have COVID in the workplace, the risk should be, if those measures are being taken, should be low, right? Because they say that the highest form of risk of transmission is when people are in close proximity to each other for a long period of time, or prolonged period. So I don't think that necessarily the job itself, like having a job that may, you may be viewed as higher risk than say an office job, will be enough to say you're not allowed to return.
Devanan has a question, and Floor, and Michelle. Selena, you're keeping track? Dev?
Yeah. So if an employee has a family member who works in the healthcare system, so his mother and sister, one works in a retirement home and one is a nurse, and I have another employee saying, listen, I don't feel safe to come to work because this particular other employee has family members who are working within the sector, the healthcare sector. Does the employee with the complaint have grounds to complain, basically that she is unsafe in the workplace?
So that can be treated as a work refusal, right? Like you may not agree with the employees. So if they're engaging in a work refusal, then remember the process that should be followed in terms of investigating and assessing the risk, taking the measures. If you don't agree with them, say, well, we think you're fine, we think it's safe. And at the end of the day, if everybody's going to have some connection with somebody who may be higher risk, going to the grocery store often, people, you're not going to be able to regulate people's lives, who they live with, what they're doing outside of the workplace. All you can do is require and take the necessary precautions that you can in the circumstances for your own workers and what you can control in the workplace. I don't think it's going to open up the floodgates, quite frankly, if every single employee is going to say, I have a relative, as a justification to return to work. But at the end of the day, if you've gone through that process, you don't agree, a Ministry of Labor inspector has come in, and I think at a certain point in time, we're probably going to get more guidelines so that Ministry of Labor inspectors aren't racing off to every single employer who's dealing with work refusal. There's probably going to be more guidance around it eventually as we're all sort of navigating this new normal. But I think if an inspector will look at it, ultimately, if the employer and employee can't agree, and then they'll say, well, you're cleared to return, or, in these cases, an individual can't return. But I'd be very surprised if a labor inspector says, you're engaging in a lawful work refusal, and somebody like that shouldn't be in the workplace. I don't think that's going to be an adequate excuse.
Thank you very much.
Thank you, Floor, and then Michelle. Floor Dandel.
Yeah. Is there a requirement for plexiglass for all the workplace, like for all the staff, desks, that they should have a plexiglass, because our chairperson measured the distance of the worker and the staff in each room, and it has a 6 feet distance. But all the workers said they still need plexiglass between them and the client.
Yeah, excellent question. So, you know, as discussed earlier, that they say that the most effective way of limiting transmission is through the physical distancing. So if you're engaging in physical distancing, probably the plexiglass will not be required for every single workstation. I think where we see a heightened need for plexiglass is if, you know, the individuals regularly interfacing with a high volume of individuals. So for example, like you see in grocery stores, retail environments, you're dealing with a number of people who are presenting themselves at the cash machine. And so there's a lot of, you know, pretty close physical interaction. And it's because they may be getting within the 2-meter range that the plexiglass may be an appropriate measure there, right? Because of the high volume of traffic and the closer proximity between the customer or the client and the worker. So I don't think most likely, you know, subject to what the Ministry of Labor is saying, but probably plexiglass is going to be considered overkill in connection with a work environment where you're able to keep the physical distancing between desks. That, you know, it's going to depend on your actual physical configuration, your layout. If people are reasonably close, then you're going to have to take, I think, the extra precautions like barriers, moving desks, right? You know, again, it doesn't have to be their requested or ideal form of PPE or solution. The employer will have to assess its needs and can implement the safety precautions that are reasonable in the circumstances. Not every single safety precaution that the individual is asking for. It's safety precautions that are reasonable in the circumstances for the protection of the worker.
Before Michelle asks a question, there is a question from the chat. If you require people to come back in the next few weeks and you have put in place all of the PPE and equipment you can think of, could an employee argue that they were brought back too early as an argument for the employer not doing due diligence?
So once the province gives the green light for organizations to return back to their physical places of business, right now that, you know, that's being limited to a narrow set of types of industries and businesses. But once they give that green light, you're taking all the reasonable precautions necessary. You can require that they return to work. You know, it's not too early if the province is allowing physical workplaces to reopen. And it's not too early if you've already put in place all of the precautions necessary to minimize these types of objections and conversations. It would be really, really good for employers to take those necessary steps in you know, having team meetings, informing employees about all of the precautions being met, so they feel some more peace of mind. Everybody's going to have a different risk tolerance. You're probably going to have a certain percentage of employees who, no matter what, are going to object or express concerns, but you can require ultimately that they return to work. Again, if they're engaging in a work refusal, remember the steps to follow under the Occupational Health and Safety Act.
Thank you. Michelle Schreier.
Yes, thank you. I just am a bit confused and need clarification early on in the morning. You mentioned, you know, about providing protective equipment as an employer responsibility, which it needs to be. But I think you said something about payroll deduction as well, and I was just a bit confused. Are you, whose responsibility is it to provide it? Is it only the employer, or I'm sorry, I just was a bit confused.
Yeah, no, excellent question. So the employer ultimately has responsibility of providing it if it's necessary in the circumstances. Not everybody's going to need people, like every form of PPE. But some PPE is likely going to be required, like hand sanitizers, sanitation wipes, face masks as necessary. So the employer has an obligation to provide it no matter what. Who pays for it is a different question, right? Can you require employees to pay for it? Well, you can ask employees to pay for it. If they refuse, ultimately you still have to provide it, but you can unilaterally, one method of requiring employees to pay for it, even if it's against their will, is to unilaterally deduct costs from their wages, right, through a payroll deduction.
That
right?
was just nasty. Okay, I get
yeah,
it.
I'm not suggesting that you do that, but I think that there's been, people may have questions about doing that. Ultimately, I think it would be, it's probably better practice to, if you're going to require it, you should be paying for it. It's your obligation, you should be paying for it. But that being said, certain people have to work with very limited budgets, and there may be cost cutting. There's other ways of cost cutting. Definitely, a fight over who should pay for it is not going to leave the employer of its obligation ultimately of making sure that it's provided.
Thank you.
We have a raised hand, Reza Kelby. If you're ready, you can go ahead.
Yes. Hi. I have a question. You already actually mentioned a part at the beginning of the webinar. So if the employee before COVID-19 normally use the public transportation to come to work, and now mentioned that he or she is not feeling safe to use the public transit, as a result, he or she want to take the car, his own car, to come to the work. Can they ask for employer to cover the parking cost as well as other costs?
So excellent question. So the employer is not obligated to pay for alternate modes of transportation to get to the workplace, right? I mean, you could always check the employment contract if there's something around mileage and reimbursement or certain allowances that they may have. You may want to be flexible about maybe attributing part of the allowance to that to additional carpooling costs, but you're not required to enhance pay or pay for these things. That's going to be an obligation shouldered by the individual. The employer won't have that obligation.
Thank you.
Any other questions? There is a question in the chat. Jonquille just referenced employers being allowed to bring employees back in certain sectors. Has settlement services been deemed essential? Settlement services were deemed essential by the federal government, meaning that you were able to continue to pay your staff. They worked from home. They worked in, some folks brought people in on staggered schedule and had in-person appointments by appointment only. There are other services like our refugee adaptation program that had no choice. So you run shelters or you run hotel programs. Your staff working in those programs continue to work. In fact, they qualified for the increase in wages we saw here in Ontario. I think there was a $4 or so top up. Having said that, all of the funders have been saying, pay attention to what public health is saying. We have had no consistency in terms of local health agencies. Some local health agencies are saying stage 3 is when they're expecting service agencies to reopen, not only our sector, but other nonprofit service agencies. Others are saying stage 2. It really is up to organization. As long as Jonquille has said that you have put proper PPE in place, you've paid attention to physical distancing that your organizations allow. Many organizations are looking at phasing in staggered schedule, so you have people working 2 days in the office, 3 days at home, changing the following week, flexible schedules to accommodate folks not wanting to travel during peak hours. So some folks might work at 10 as opposed to 9 to avoid the 8 a.m. travel when public transit is so crowded, may work later. So those are all the things that are being looked at. There won't be a call that says, okay, settlement workers, you can now all go back to work. That is being decided on a regional level. you won't get it from the funders, you won't get it from OCASI, but we will pay attention to what our local public health is saying and what the province itself is saying in terms of the service sector. But in Ontario, the intelligence is saying stage 3. And as you know, every place in Ontario except for Essex County is now at stage 2.
And it's what I'm hearing as well, outside the settlement sector, just in just by way of comparison, the financial services sector. I work downtown Toronto in the financial services area, and a lot of the big financial institutions, larger companies downtown, a lot of them are saying, notwithstanding that they may be cleared sooner, a lot of them are not coming back to the physical workplace until the fall, most likely, and some later. So even if you are given the green light, you can make an internal decision as to whether you feel ready or comfortable. You don't have to return to the workplace yet if not satisfied that you're ready to do it. And a lot, interestingly, a lot of organizations are reassessing their permanent needs. Some organizations, after having, through this pandemic, are assessing, do we need everybody back into the workplace? Can we make some arrangements remote on a go forward? So that's also an analysis that a lot of agencies are doing. That Shopify, for instance, being one major organization who said we're not coming back to the physical office. Everybody's remote now. So some may like it, some may not. There could be, employment-related disputes that flow from a lot of these permanent changes, but you don't necessarily have to go back right away. And some organizations are opting actually to wait it out a little bit further.
Absolutely, and that's the conversation that's happening in the settlement sector as well. There is an understanding that our new normal, to use that very overused phrase, will be there will be in-person services, some service. A particular service might have a blend of both online and in-person funders, as well as provincially. So what does this new normal look like? What we're saying is that this conversation and the decisions have to be led by the sector as opposed to the funder, and I think the funder is open to this. However, there's no expectation that everyone is returning to their offices, that everything will be 9 to 5 and everything will be in person moving forward. But Jonquille is right. What I've been hearing from your colleagues across the province is that folks are looking at September as their date of return, barring no new, barring another outbreak, of course, which may just take us right back into emergency mode. So we have 10 minutes left. Any burning questions? There is a question here. Our office is located in a medical building, and we have been given clear guidelines. Okay. Yeah, so the building has given clear guidelines. However, it does not relieve the concerns that folks are having. Yeah, I think it's common sense, right? Listen to your public health authorities, ensure that you have PPE in place, ensure that staff can do physical distances, pay attention to common areas, put things in place to accommodate staff as we move forward. It's changing week by week, if not day by day. So Jonquille, I'm not seeing any other questions. Selena, are you seeing any other hands?
Vidya has their mic unmuted. I'm just wondering if they have a question, as well as Jessica Marcotte. Those are the last two.
Okay, go ahead if you have a question.
Vidya, would you like to go ahead? You're unmuted.
Selena, you need to speak up louder, please.
Sorry. Vidya Salvaraj? If there's no question.
Yes,
okay.
Yes, I do have a question. Going back to the workplace, it is possible like some employees will get sick, say for example, common cold or like flu-like symptoms or something like that, but not necessarily COVID-19. So the remaining staff may feel uncomfortable, saying like they are not feeling comfortable working with this staff. So in those situations, how it can be dealt with?
So, I mean, with COVID-19, it's very common, like symptoms that can, so it's not cold may also be very similar to symptoms that are COVID-19 related. So I wouldn't necessarily make any premature conclusions about what the situation is. If it looks like it could, there's reasonable grounds to believe it could be COVID-19, you should be directing that individual to seek their, to go get testing. And then the employer can determine whether there's any risk of exposure or duty to inform other employees who may have been exposed. But individuals who are feeling unwell, you should generally require that they work from home, or they're, otherwise they stay at home. So that's what the health recommendations are at this time, is that employers just require employees, if they're feeling unwell, to stay at home. Shouldn't be in the workplace, period. I don't think that will necessarily excuse every single employee in the workplace from saying, I'm not coming in tomorrow because so-and-so had a cold. Now I think I might have COVID. There has to be a reasonable basis for their refusal to work. A theoretical or remote fear will not be enough to justify, refusing to come into work if safety precautions are being made, right? Like, that's the whole point of the physical distancing, is that even if somebody may have COVID, the risk of transmission is low because you've been honoring and requiring employees to physically distance, because of the PPE, because the workplace is being regularly sanitized. So this is why these measures are being put in place, specifically because we're trying to limit exposure to others, to avoid a situation in which we're in complete shutdown. So I don't think that will necessarily be enough. If you're satisfied this isn't a COVID case, somebody might be sick, that therefore that other employees are justified not coming to work.
There's a question. Can organizations remove fridges and microwaves, for example, from their offices?
Yeah, excellent question. There hasn't been a lot of guidance on that. Like, they're saying that you should be wiping down, desanitizing common touch surfaces, but I think the better practice is common utensils, like kitchenware, dishware. You may want to replace all of that type of stuff with, like, paper plates. I know it's bad for the environment, but straws, paper plates, plastic cutlery, that type of thing, instead of reusable items, or situations in which people are reaching for cutlery and they may be inadvertently contaminating other cutlery, that type of thing. So a better practice might be to move towards disposable dishware, things like that. Appliances, as long as they're being desanitized, if everybody is wiping it down, using hand sanitizer in common areas, the risk of transmission is low. Things like coffee, like common coffee, you may want to just cut that out out of an abundance of caution to reduce the risk of spread, right? It's avoiding the need to have to, because even if you do wipe things down, there's you're not going to be able to possibly capture every single thing that everybody, or spot where people have touched. So I think the practice of, for general appliances, that they wipe it down after use, that they make sanitation wipes available, hand sanitizer available. Common, like coffee machines, water coolers, you might want to just, not have employees use that type of equipment, or common food, things like that were previously available. I would just cut that out for right now until we get guidance.
We have one last question. Jessica Marcotte, she has her hand up. If you'd like to unmute yourself.
Hello?
Hi.
Hi.
Oh, hi. So in regards to removing a water cooler, or, well, that's my main concern, the water cooler, does the employer have an obligation in terms of providing drinking water? Just because, like, if they're removing kitchen access, which removes, the access to running water, and then they remove the cooler, how do employees actually get fresh water to drink throughout the day?
Well, employees can be asked to just bring their own water bottle, or go to, the local store, restaurant, wherever, to buy water.
Okay.
So you can also alternatively provide water bottles, right? Individualized, it's bad for the environment. I hate this, but at the same time, safety is paramount, and so alternate safer options, which could be to provide separate water bottles.
Okay.
Disposable.
Our colleague Cheryl Fresh just reminded us, our tap water is safe.
Yeah, I mean, yeah, they can use a disposable cup, for instance, and take some tap water. Toronto's finest.
Yeah.
Yeah, it's just unfortunately with the kitchen being closed up, we are now then we only have access to a public bathroom, which actually increases traffic and touching faucets and stuff. So I'm just trying to determine at what point.
Water bottles might be an appropriate alternative for asking employees to bring in, their water or refreshments.
Okay. All right, thank you.
Great. With our 2 minutes left, let me give a big thank you to Jonquille. This was so informative. You will see from the chat, there are lots of thank yous and how informative and concise and clear this has been. Jonquille, thank you so much for 2 hours of good, solid information. We love the presentation. We may be knocking on your door again in the next few weeks, asking you to do something similar, because as we know, the sector is fairly large and questions continue to come up. Thank you so much for all of your questions and for supporting each other through the chat. Have a wonderful, wonderful day. We will send out the slides to everyone, and we will inform you once our recording is available for you. Thank you, Jonquille. Thank you, everyone. Have a wonderful Thursday afternoon. Thank you, Selena. Fabulous job.
Thank you all.
Bye-bye.
Thanks for the excellent questions. Thank you. Bye-bye.
Thank you.
Thank you. Thank you so much, Debbie and OCASI. This was very, very helpful. Really appreciate it.
Thank you, Dawn. I appreciate that.
Okay, stay safe and have a good summer.
You too. Enjoy that wonderful place where you live.
Thank you.
Love that part of the province.
Thank you very much, Debbie.
Thank you.
Thank you, Debbie.
Thank you. Have a wonderful afternoon.
You too, and stay safe.
Thank you. You too.
Thank you. It was very informative. Thank you. And
thank you, Cristobal.